Tom, take it away.
Okay, it being 4:31 on the 15th of July, let's call the meeting to order. I can see all members of the commission are here as well as our chiefs. The second item of the meeting will be approval of the minutes. If people had a chance to look at the minutes, and if you have, is there a motion?
One question or clarification. I saw, and it's on page 2 of 3 of the minutes, the last paragraph of section 3. There's reference to the city meeting 6 of the 8 can't wait items. And I'm wondering, Chief Brecklin, if you could just expand on that a little bit. I thought we did meet all 8, but maybe we had work to do in some of them, which makes sense.
Yeah, that was the chief's report. Chief, you want to cover that a little more?
Sure, yes. We do, we're very solid on 6 of the 8. 2 of them need a little bit of work, but they are contained and or referenced either through training and or policy. One thing that we are actually in the process of, the draft has just been sent out for a temporary directive on a duty to intervene while we continue to update the use of force policy to actually contain that language. So we felt it was important in the interim to put that in writing. We've been training on it for years, but we wanted to get it in writing for a general order, so that's in process, and the use of force policy is actually in the process of being updated in its entirety.
Would it be accurate then to say that the city meets all 8 of the 8 can't wait items, recognizing we have some work to do on some?
I'm comfortable with that description, yes.
So then I'll propose to change the minutes in that section to say they meet all 8 of the 8 can't wait.
Okay, are people okay with that? Then we'll make that change. And are there any other potential changes to the minutes? If not, is there a motion to approve? Please.
Comment. Okay. So I like the honesty of the statement in some regards, and I agree that it's good to say that we do meet the 8 of the can't wait. But I think I would like to not eliminate that other statement completely, because it's an acknowledgement that we are still moving forward, processing what we have and trying to improve. And I think I would like to capture that in that statement. So that's my only comment, if you guys...
Then perhaps it should just stay as is, and then when we have it fully updated, we can go from there.
Okay, Chad, could you repeat your comment? I didn't hear it that well.
Then perhaps the minutes should just stay the way they are, and we can go advance further once the policy has been fully updated.
Sure, I think it makes sense. I mean, whatever's accurate, knowing that we can always do better.
Okay, but it is something for us to be aware of, so. Okay, with that, we still need, I think, a motion to approve the minutes.
I'll make a motion to
I
approve.
motion to approve the minutes unless somebody else has another comment.
Okay, Jeff, is there a second?
I'll second.
Okay, Jim seconds. Any other discussion? Okay, all those in favor of approval of the minutes signify by saying aye. Aye.
Aye.
Aye.
Aye.
Okay, minutes are approved. The next agenda item will be, are there any public appearances? Anyone at City Council or online who has an appearance for a non-agenda item?
There are no public appearances.
Okay, thank you, Sarah. That takes us to item 4, report from the police department. Staffing report. Chief?
Yep, the staffing report probably in front of you. It was attached to the agenda. There were no changes from last month's report. We are currently have no department vacancies. We had communications with the academy director at Blackhawk Tech, and as of today, they are still planning on beginning July 27th, but as with everything COVID related, it's a day by day proposition. So we'll see, and we certainly hope that we can get that officer into the academy on the 27th. But otherwise, that's where we're at.
Okay, any questions from any of the commissioners? Okay. If not, then let's go to item 5, report from the fire department. Chief?
You have the activity report in front of you. It gives you an idea of what our activity response-wise has been, and then our staffing on the second page. From a personal note, or actually some of the things that we've been working on, I did send out a letter to some of our civic leaders, trying to engage them in a focus group to address recruitment and how we best prepare our recruitment effort, outreach, all of that stuff. So I guess I'm going into it with an open mind, not trying to establish too much of an agenda. There's a lot to be learned as far as some of the things that we can do from an organization to better reflect what's happening in our community and how we can reach out to those who may be interested in the emergency services. So that letter did go out. Actually, Jim and Rosa are both invited to participate on behalf of the Police and Fire Commission, but also because of the fact that they have some knowledge from a public safety standpoint, and when we're talking about communities of diversity, it makes sense to involve them as well. So the letter did go out, and now I'm just waiting for some schedules so that we can coordinate them. Looking at the first 2 weeks in August, in order to have the focus group. Our ability to meet in person will be contingent on the recommendations of Dane County. I would like to establish a hybrid approach to that. Because of the fact that there is some value in face-to-face conversation. Nonverbal communication is pretty significant, and it gives us a better idea that we're on target. So that's all part of the staffing report. Our drills have basically been impacted by our ability to meet as a department. So a lot of what we're doing is being done online or when they come into work. Other than that, our numbers are consistent with what we see typically. The ebbs and flows of our membership based on those coming in and those who have moved on.
Okay. Are there any questions from the commissioners on the staff report? I guess maybe I have one quick one, Chief, and that is reference to the 2020 annual work plan timeline. Mm-hmm. And that is, would have been developed in January. I would assume that you're going to have to make adjustments based on COVID.
So actually, the work plan is still what it is. The adjustments on this plan won't necessarily be adjusted because I want to be able to report as to why those expectations weren't met. So if I start changing it here, it's going to look like we met those expectations based on the changing of the schedule. The fact of the matter is, this gives me a really good idea of what's not being met, what is due to COVID, how much of that is staffing related, those types of things. So where this will likely see an adjustment is with the revision of the next work plan. Typically in these Gantt charts, what we will do is we will address that through a narrative versus adjusting the bar chart.
Because as it relates to the Police and Fire Commission, in particular, the 2 points of recruitment and retention, you know, that's something that obviously we'll want to continue to pay attention to as we move through the year. So
yeah, well, recruitment and retention, that's been happening regardless of COVID. The things that we weren't necessarily able to accomplish are things like our awards and our pinning ceremonies, which are retention issues. I mean, obviously, we want to recognize our employees for the work that they do, and it allows us to make sure that they know that they're valued. It does help with retention.
Okay. I guess the next item then would be the notice on the paid on-call firefighter resignations.
Yeah, so some of these have already been reported through other staffing reports. The one that you have in front of you today is for John Venturino. John had some work-life commitment changes, so he submitted his letter of resignation. We also have a couple of others that have recently submitted. Jared Dunkey, for example, he took on new obligations through work and has family commitments that prevented him from participating. So we received his letter of resignation. I just received another, basically it's not a resignation yet, it'll be a leave of absence. We have a firefighter that was just employed by the City of Brookfield Fire Department. So he will be transitioning to the east side of the state. The others that I can report on, basically I have 4 others. One went to basic military training. Another one was unable to commit based on obligations. I have one that moved to Colorado, accepted full-time employment as a firefighter there. And then I had another employee that just wasn't participating any longer. We reached out to him and we accepted his resignation. So that gives you an idea of what amounts to 6 people on my list, 7 if we include the individual that came into my office today.
Okay, and I have to take a look to see what percentage of the vacancies of that paid on-call are currently open.
Well, as you can see, our total head count is down by 10. And that's reflective of our head count right now. But that is typical. We'll see that go down to 20 sometimes, and it really is based on when we're bringing people in, when we're training them, and when they find employment elsewhere, or they have decided that they can no longer give as much time to the fire department as they once did.
Okay, thank you. Any of the commissioners have further questions on that? Okay, if not, let's go to item 6, which is the city's process for resignations and discharges for sworn officers and use of parallel proceedings. This is a discussion item. What I think prompted this is, if you recall, we had an officer who resigned, I think probably 2 months ago, and we're not going to go into the particulars on that. I think the chief already covered that in closed session. But Tom O'Day brought up a good question, which is for the city to, I think, kind of go through how they do parallel proceedings and how they make determinations as to when somebody will be resigning as opposed to discharge, which falls into our jurisdiction. So really, it's going to be, I think, Chad and Sarah explaining, the issue. In particular, the police and fire commission was, and I think Tom raised a good point. We want to make sure that if somebody, does resign, that the record is there so that, wait a minute, there was an issue here. So, do you want to cover that, Chief and Sarah?
Is there anything that wants to be added before we comment, so we can cover it all at once?
I'm sorry.
Well, I'll outline a little bit more what I was thinking. So I understand in the private sector, it's common for an employer to offer an employee who may have otherwise engaged in or suspected to have engaged in misconduct, to offer them the opportunity to resign in lieu of termination. I, as a policy matter, don't think that's appropriate for the public sector. And as more attention is surrounding the idea of making sure that the public is aware of misconduct, both allegations and actual charges verified against law enforcement, I think it's important for us in Fitchburg to recognize what the policy is. If you had an employee, a police officer or a firefighter who was under investigation, would you offer them the opportunity to resign in lieu of pursuing charges? And then where does that fit in with the city's policies?
So I won't go into too many details on the case that's brought this to the limelight here. But what I will say in that particular case is there was not an offer to resign in lieu of termination. That employee was notified that I was going to be seeking termination through the Police and Fire Commission and provided with the date that I was going to be doing that at your May meeting. And that employee elected to resign prior to the charges being brought. So since they had resigned, what charges would I bring against an employee who has resigned employment from the department? So in that particular case, there was, it was completely how we would do it in a transparent manner, being upfront with the employee on where we intended to go with the situation. And before I can file charges with the PFC at your next meeting, they elected to resign. So how we would report a situation like that is there would be full transparency. We are not interested in having any officers that leave our department be hired by another department if they have performance-related issues or integrity or other issues that would be a concern for us. So much like we would hope that we would get full transparency from any other department if we were looking to hire a current or former officer. In the particular case from May, we report to the State Department of Justice when we removed them from our roster that they resigned in lieu of termination. So the state database will reflect that that situation was there, so that if anybody were to do a background on that individual or anyone in a similar situation who has resigned in lieu of termination, they will have that information as they make their hiring decisions. We also have the option to report to the DOJ a resignation while under investigation. So if an employee were to resign prior to charges being filed with the PFC, we still have the ability for full transparency there in the state DOJ database. I can assure you I am going to operate with nothing but the highest ethical standards of transparency and ensuring that we have good police officers here and that we are not having any of our police officers who don't meet community expectations getting hired anywhere else without that department having information. And if they elect to make a hiring decision that would be contrary to what we would do, I guess that's their prerogative and their community will have to address those issues. So much like any significant personnel issue, we consulted with labor attorney throughout the entire process to make sure that we were doing things legally, appropriately, and following all appropriate protocols and regulations. So, and as far as parallel proceedings, again, anytime we have a case where an officer is alleged to have committed criminal activity or potential criminal activity, we are going to seek an investigation of a criminal nature by an outside agency. We are not going to investigate our own. We want to be transparent. We want to ensure impartiality. And that's what we will do in cases moving forward. Criminal investigations are completely separate from any internal administrative personnel investigations. They remain separate from one another. We obviously have the ability to compel a statement in an administrative investigation. That cannot be used, a compelled statement cannot be used in a criminal investigation. So, and in this particular case from earlier this year, the decision to seek termination was made absent of any criminal charges there. So we made that decision based upon the outcome of the administrative investigation, not where the criminal investigation was headed. So I hope that answers the questions. I hope it gives you the assurances that this commission needs and deserves, and that our community needs and deserves, particularly in the current current situation policing finds itself in, with questioning of credibility and questioning of accountability. So again, I will assure you that you're going to get accountability from me and you're going to get ethical behavior from me. So hopefully that addresses anything. And Sarah, if you've got anything you want to add from the city perspective, feel free.
That was perfect. I really don't have anything else to add. It's just that for any employee that is in a situation where they may be terminated or potentially be offered the opportunity to resign in lieu of termination, that doesn't really happen. But we always consult with our employment attorney, and it's always a case-by-case situation. But we've been really, really lucky here where we don't have a lot of those situations at all. So.
Thank both of you for those explanations. I think it was good to get a full explanation, everything out there. This is how it's done, and help reassure that we know that the city's doing the right thing when it comes to these situations. Any other thoughts or things on that? If not, I think this might be one of our last rules revision where we take a look at it and make some changes, and then I think Sarah's going to be able to take it to the city attorney, and at our next meeting maybe we'll figure out ways to make sure that the public and the unions and everybody got a chance to look at it. So with that, let's go to item 7, discussion and input for PFC rules and regulations update.
Joe, do you mind sharing your screen so that people can see the PFC rules and regs, the one I emailed you? Thank you.
Yep, I'm working on it. Stand up.
So when he brings up the document, I highlighted in yellow anything that we still need to talk about, just to try to help keep it a little bit easier. So feel free to, we can kind of start at the top and work our way through.
Yeah, that was very helpful, thank you, because that leads us right away to, I think the first thing highlighted in yellow. And if commissioners have something else they want to bring up that's not in yellow, please let us know, but let's go right through what's highlighted in yellow.
Actually, can I just make one point? It's very minor, but in the mission statement, so we have statutes throughout the document, so that I think the public can look at this and then they can look into what those things actually are, and so we actually can as well. But in the mission itself, the last sentence, the Fitchburg PC does not have optional powers. Optional powers is something that we know as a group, I think, but I don't think that the public would. So I think we should just have the statute in there so that people that are reading this have a reference.
You bet. That's a good idea.
Sounds good. Thank you. So next would be under 2.1, appointment of the chief and fire chief in the event of vacancy. So what's in yellow is, in the event of the vacancy, the city has an already established succession process, needs legal review. So, and I think it is true that there is a difference between the short term should be, kind of designated as the process, but the long term, then it's the PFC's decision. Sarah, are you going to have them review then what the...
Yeah, I can send this as is and see if there's any recommendations for that part, if you like, unless anyone wants to word it.
Because I think it would be good for the commission to get the commission's reaction to what legal is suggesting.
Mm-hmm. Yep, absolutely. I can run that by legal and see if they have any suggestions for that, for the short term and long term.
Any commissioners have ideas right now what they want to see?
Hey Sarah, point of clarification real quick. As I'm going through this and sharing my screen, are you making the changes, or do you need me to make changes as we go?
Nope, I'm gonna make I'm marking the changes, so I can't share my laptop, so since you're in Zoom, that was the only way. So nope, you don't need to make changes, I got it.
All right, thank you.
Yep.
Okay. So the next will be...
Rosa.
Hold on. Am I on? Oops. Can you hear me? Okay. Just going back to that, who brought up the fact that this needs legal review, and what was the reason?
Yeah, that was brought up at one of our PFC meetings, and I don't recall exactly. We needed to identify a short-term and a long-term succession process, like in the long-term or short-term, who was going to assume the role. I think we wanted to put a time on it, if I recall. Does that ring a bell for anybody? It's been a while since we were on this
Yeah.
section.
Yeah, well, I think when we outlined the process, which is probably sometime last year, we identified that once we had what we had put together, we did want to have it go through the, legal review, so.
Oh, because if the city has already established a succession process, is that written somewhere?
Well, we don't have a succession process. I think what happens typically is the deputy assumes the role of the chief if the chief were to leave while we're recruiting. Is that correct, Chief Brecklin and Chief Pellemacher?
That would be typically correct. I was just gonna try to pull up the employee handbook to see if there was anything mentioned in there, but I don't know as though that there is.
So, Sarah, I'd be surprised, I would expect it to be right in the position descriptions of the deputies, or assistant chiefs that they assume when the chief is unavailable.
Right, we do have that in job descriptions, but I mean, this is implying like the chief is gone, maybe they've left employment. So I mean, typically, yeah, your deputy would fill those shoes in the interim.
So I think that this would be a situation where I assume that that's why the legal review is in there, is to kind of, the city needs to have a more formally established process in its employee handbook. This would be a good place to put that, or this would be a good time to include that. But typically in the absence of a chief, whether they've departed the agency or whether they maybe are on a medical leave or whatever the case may be, then clearly the city would want to typically appoint the deputy police chief in the case of the police department. I don't want to speak for Joe and his operation, but if there's going to be a long-term vacancy, or perhaps the city does not feel as though the deputy police chief is in a position to assume that role, there would be a conversation and or recommendation from HR to the Police and Fire Commission to perhaps, identify an interim police chief from outside, a recently retired chief or something along those lines, depending on what the nature of the reasons for the departure was. I mean, in a worst case scenario, there's unethical behavior from, in our case, the top two people, and you may not select a lieutenant to assume leadership of the department. It might, again, be an outside person. So I think it's a good time to find out what we should do to codify what process the city would use, but ultimately the PFC needs to affirm that decision or go in a different direction.
Right.
Is how I would see it.
The other thing that I would add to that is, once again, it's situation dependent. In a typical day in, day out situation where the chief is maybe on vacation or has something that does not allow him or her to be in the fire station, you would follow your chain of command. You wouldn't necessarily want to put yourself in a position where the third in command was put in charge over the second in command. I mean, just look at that from a military standpoint. You wouldn't have a major to step over a colonel in order to be in charge. I mean, you would use your chain of command in order to make sure that the day-to-day administration of the department was handled appropriately. Hopefully your second in command is placed there because of the fact that they may be in a position to assume command of the department. So that's the day-to-day. In the other situation where you are looking at an interim fire chief or police chief, that would typically come through your commission, and then even the city elected officials and city management, they want to make a decision as to the direction of the department and whether you're bringing people in from the outside. So I do agree with the fact that the process needs to be identified, but to some extent, for the day-to-day, it's already there.
Question.
Okay. Go ahead.
I don't have any disagreement with what's been said. It's just it's not clear where does the responsibility to do this lies. If it's on us directly, or if it's somebody else in the city, either HR or whoever. So that's not clear to me. If it's us, then we need to just read all of this.
To answer your question, Rosa, I think we haven't spelled out, you know, what's day-to-day is spelled out, you know, either by, you know, the, position descriptions or the, you know, the sequence displayed there, or as Joe said, you know, basically kind of, here's the rank, it goes right down the ranks based on, where things are at. But for the long term, there, that falls into the PFCs, you know, we're searching to get a replacement issue. We've got something temporary, but, you know, then we're gonna be looking at, you know, the long term, you know, or if it's a longer term fix until we get it fixed.
I think you need to look at it from an employment standpoint. If you're gonna be putting an interim into place, that should be considered, temporary employment, either bringing somebody in from the outside or the next in command, because they would hopefully be paid at the level that they're working. So, maybe that is a police and fire commission, issue because it's an employment issue.
Okay, are there other thoughts on here as we move this to get kind of rewritten? Sarah, I can work with you and the attorneys, we've got something a little bit better to react to, as I think about it.
Yeah, it seems,
I would just add that I think that we should have something as far as notice to the PFC, because the quicker that we do get notified, we might want to call a special session, we might want to, like, depending upon what the circumstances are, and I appreciate very much that this could say could manifest in just about any way. But we should have something in regards to timeliness of notice, so that we can make a determination on what our role really should be, given the events.
Yeah, that's a good call.
yeah, it strikes me that, I mean, two questions that I would have. One from the city, do we have a succession plan in place? And if that's in the handbook or somewhere else, it sounds like not.
We do not have a succession plan in place.
Okay.
It's been talked about, and it's something that we'd like to do, but we do not have a formal succession plan in place.
Okay. And then secondarily, and I think this is the legal question, who does put that succession plan in place? Is that the city? Is it the PFC? Is it the chiefs individually deciding how they want that to work? I guess that's the legal question that I think and I don't think I was here for this discussion. That's probably what I'm guessing was the issue.
I'll find out. I can talk to legal and ask them, you know, whose purview is that? Is it the PFC? Is it the city? Who is supposed to be putting the succession plan? I mean, it does say the city has already established a succession process, so it seems to me like it implies that the city's, that's the succession plan we're following, but I can certainly run that by Westcott.
I think it's definitely going to be dependent upon the circumstances, but I think in most cases I see a recommendation coming from the city through Sarah and HR to the Police and Fire Commission to say, you know, whomever is gone, they've resigned, they've retired, they're in a medical issue, they've been fired, whatever the case may be, and, you know, in the interim, we're going to recommend that the deputy chief is made the interim chief. You know, we know that this is going to be a protracted situation, or because there's a problem with the deputy chief, as I mentioned, if there was, you know, two people maybe fired, or the chief is fired, but clearly the deputy chief had knowledge of what was going on, then that could be a recommendation from the city that says, we're going to look to put an interim person from the outside in. But I think in any case, that has to be approved by the Police and Fire Commission. I think that's safe to say by statute. So it's just a matter of, again, codifying what that looks like and who's bringing it to the PFC, so that it triggers that discussion and that plan put into execution.
It's a good explanation, Chad. Okay. So on this, Sarah, you'll be checking with the city attorney. Will we have some language that has what, so it is a little more clear?
Absolutely, yep.
Okay. The next yellow highlighted area is under section 4 promotions, 4.7. Sarah, maybe you want to give a little background on your research on the issue of promotions and also having periods.
So we reached out to some comparable communities. So we often compare, Fitchburg often compares themselves to Verona, to Middleton, and then also to some prairies. And so all three of them do have probationary periods for their sworn, non-represented employees. employee, so it's a 12-month period. Some period calls them evaluation periods, not necessarily probationary periods, but so looking at other municipalities, I know that was something that the PFC wanted. We're an at-will employer, so that means that employees can come and go as they please. So whether they're resigning or we're terminating, as long as the employer's not doing so in a discriminatory, retaliatory, or otherwise prohibited way, as an at-will employee, there's really no need for the probationary periods. The probationary periods are kind of mute, so it's up to the PFC if they want to have the probationary periods for the non-represented for the promotions. But if that was something the PFC wanted to do, I would certainly like to maybe call them trial periods and allow for the employee to go back to their former position if they're not successful, just so that we don't lose somebody who maybe took a management position and it wasn't a good fit, but here they've been with the city for 10 plus years. So just a thought, but that's just a little bit of background of what I found out on what other comparable communities are doing for probationary periods for promotions.
Question?
Commissioners' reactions or thoughts?
It's me.
Rosa.
Okay. Like I talked to Sarah about this earlier, and of course I noticed, the city of Madison has probationary periods in other municipalities around here. In our last meeting, I recall that I asked, or I heard that we used to in Fitchburg, and then that changed. And I think it was the chief who, you've been here the longest, so I don't know if you were able to find out why exactly that changed. Because I would hate to do it arbitrarily. Oh, sure, let's have a probationary period for promoted positions because other municipalities have it. What's the advantage of not having it, or what's the advantage of having it? And that's what I have not heard yet. So, I don't know, Chief, if you were able to give us some historical.
I'm finding in my advancing age that my ability to go too deep into the history annuals is getting more and more challenging. However, I think that this changed perhaps around the Act 10 timeline is where I believe it changed. I can't say that for certain, but the city did an extensive rewrite of its employee handbook at that time, and it would be my best recollection that that's likely when it happened. I know that there were some concerns in the city, and I don't know the timing on that, but in the early to mid 2000s, there were promotions made within the police department, and I know with a 1-year probationary period at that time, there were people being promoted to sergeant, and on day 364, they'd walk into the chief's office and say, yeah, this isn't for me, I'm going back to patrol. And you then lose a year of growth and development there, and now you're back into a promotional process, and somebody new is now beginning to start that growth and development cycle. So I was not involved personally in any sorts of conversations related to the removal of probationary periods, so I don't have any of the historical context as to why it was done. I can merely only speculate. But my guess is that it would have happened either right around Act 10 or maybe a couple of years before that. So we're talking maybe 2009-ish, somewhere in there.
But we do have orientation periods, so we do look at progress and their performance through what are called orientation periods. So, like an exempt employee, for example, we look at quarterly for the 12 months. It doesn't mean, though, that they're if at the end of 12 months they're not at the performance level, then they're out of a job. It's not a true probationary period, but we do have these orientation periods where we do evaluate their performance. I'm looking at the employee handbook right now where it talks about these orientation periods. So it's not a traditional probationary period where you're on a strict 12-month period where anything you do could be cause for termination potentially. That's really the probationary period. It's putting down that expectation. This is the behavior that we want from you, and laying that out. Some employers will reduce pay for that probationary period, or not. You're not eligible for benefits during a probationary period. So that's some of the things that employers can put forth when they have those probationary periods. But we still evaluate our employees when they're hired and or promoted.
Are there any other commissioners that have thoughts or comments?
Chad,
Go ahead.
Chad, could you remind me, I think the last meeting we had talked about if a person got promoted and you're hiring the replacement, that person could not go back? Or that person would not have a position?
That could be possible. Based on an agency our size, you have 35 police officers and 8 sergeants, and that's the easiest example to use is the sergeant or officer to sergeant transition. So if, in January 1, we make a promotion to sergeant, and then we'd need to do a hiring process, then we could potentially have the police officer vacancy filled, 5-6 months later, and then at month 11, when the probationary period is coming to an end and the sergeant says, yeah, this isn't for me, or it's not working out, I'm not happy in this role, I'd like to go back to patrol. Well, we may already have 35 officers filled, the positions filled. So then we'd have to have a conversation. I mean, I think it would be rare, but if none of those 35 officers wanted to participate in the promotional process, then what are we going to do? So that's one of the potential issues there with the probationary processes. The city did implement a policy that does allow for a voluntary demotion, where in that case a sergeant can go back to being a police officer so long as there is a vacancy. So, because the last thing you want to do obviously is invest in a hiring process and go through field training and all of that, and then potentially 10 months later you're bumping the least senior person out because somebody's decided to go back into a voluntary demotion. Now again, I think that would be rare, but it is possible. I mean, typically you are hopefully going to have somebody or more than one person interested in taking that promotional opportunity. And I think it's also critical for the city / the police department in this case to evaluate what's happening in these positions that would potentially cause people to want to voluntarily demote, and ensuring that it truly is just a fit issue, that this person was performing acceptably, the position, there's nothing that needed to be changed significantly about the position and those sorts of things. That constant self-reflection and self-evaluation, if you will, of those roles, to make sure that we're not doing anything unnecessarily to contribute to that desire to want to voluntarily demote.
Good. I was going to say, after listening to all this discussion, the one thought that struck me, especially when you put it in light of the other 3 communities, still having them, but I don't know that we want to call them probationary periods. I'm wondering if we were to put all promotional appointments, and then the question is may or shall, have a performance, new job performance evaluation period of 12 months. This may be waived after 6 months, so that we're clearly in an evaluation. Are they meeting the new job standards? If they are, because you're going to have a performance evaluation every year, or, formalized, but we want to make sure that on promotion, that they are being evaluated for their new job duties. And so anyways, that's just the thought that crossed my mind.
I guess a couple thoughts. One, clarification, Sarah. So Sun Prairie, Verona, Middleton, they have probationary periods for promotional appointments?
Represented sworn officers.
I mean, and now I'm just kind of thinking out loud. So under statute, these sworn officers are protected by the just cause standard by law. So probationary period doesn't do anything for us with respect to a just cause standard for terminating or disciplining. Chief, if I remember right, I heard you say it may be a recruitment issue last week. If we're trying to hire from the outside and the recruit knows we have a 12-month period where we're calling them probationary and it may not work out and they may not have a job in 12 months, that may be a recruitment issue. But our peers sound like they do 12 months anyway. So like Rosa, I'm trying to figure out what are the pros and cons. I'm not seeing a whole lot of value in a probationary period for a promotion, unless Chief, frankly, both chiefs, you think it would be helpful.
I think for internal promotions, you know what you have there. I think that's pretty evident. And so long as we're doing internal promotions, I don't really see a need or a huge concern to have promotional periods. And clearly there's basis behind the decision from the city at some point in time to remove that from promotional consideration. You know I brought it up earlier, you know, if you do a promotion from the outside, you know, you don't always necessarily know what you have, and you only have the background investigation to go on and some performance evaluations. That's where I would, you know, if we were going to have probationary periods, that's where I would see them. But again, I don't know as though we want this to completely complicate the rule rewrite either, and I think we have to weigh that. And much like we had talked at one of our other meetings, in order to address the situation, is it as simple as just stating probationary periods may be utilized when, you know, when determined, you know, necessary, appropriate, reasonable, obviously with approval of the city and the Police and Fire Commission. I mean, that could be a way. Obviously, you want to look at how you treat situations, and, you know, it could be viewed from an inequity perspective if, you know, the last 3 sergeant promotions we did because they were internal, there was no probationary period, and then the 4th one, we selected an outside candidate, and they've got a probationary period. So a lack of consistency could create feelings of inequity and unfairness.
Yeah, I would agree with the lack of consistency could lead to a problem. The thing I wondered sometimes, even for the internal, even if it's you know, from a field officer to a sergeant, sometimes you get people that are very good field officers, but they're not necessarily real good at supervising, you know, their former coworkers. And of course, that's something that you weigh when you're hiring people. Are they going to be able to separate out? But I don't know if that's an issue where you want that to be able to weigh that, or that hasn't been an issue.
So if I may interject a little bit, right? I think one of the things that we have to ask ourselves is what we're trying to accomplish with the probationary period. If it's the ability to remove somebody from that position, either through demotion or through termination, and we're bringing people in from the outside, it's not in our best interest to just let them go, which is sort of what probationary period suggests, is that you can let them go for any reason that would be deemed appropriate for that level of discipline. But I think for the most part, whenever we're dealing with discipline, we're talking about progressive levels. And just because you don't have a probationary period doesn't necessarily mean you can't terminate. Anybody you're bringing in from the outside, you're not going to want to let them go with the first violation that they made. You're going to want to address that. There's going to be another meeting after that, and if they're not meeting expectation following those meetings, well then, yeah, then you look at termination. But I don't think that's going to happen any differently if you have probation or if you don't. You don't necessarily just want to let someone go. They're filling a need that you had asked for, and you got to give them an ability to learn. In some situations, it's going to take more than a year to be able to pick up certain things, especially if you're coming into an organization. So from a probationary standpoint, I love the idea of doing that with your new hires because they haven't necessarily established themselves in the profession. But once we start getting into promotions and you start getting into the highest levels of public safety, hopefully they've established themselves to the point where your background investigation is going to prove them to be a valuable candidate. So that's just my opinion on it, given the fact that, you know, probation or the lack of probation doesn't necessarily take away the ability for us to address whether they're right for that position, and then to allow the process to sort of work its way.
Okay, other commissioners, let's try to maybe wrap this up with some closure. People have thoughts on bringing closure to this issue, or way to address it? Because we are kind of all over the board a little bit yet. Jeff, you got a feeling?
I assume that we have to decide if we wanna get rid of this or not. So that will be.
I mean, one option we could do would be to simply say, okay, we've really looked at this quite a bit. We didn't come to a full resolution. We can put it in the parking lot for a year, because we're gonna, I mean, you hate to, basically push something off for later when you can make a decision now, but I think, we've looked at other agencies, we've studied this, but we still don't, at least what I'm hearing is that we don't have a consensus. So, other than if I probably maybe hearing more people say, let's just not have the probationary period and just leave it at that.
What if we do, and it's along the lines of what Chief Breckland suggested, and I'm looking now at 4.13. What if we change that to say the chief may establish a probationary period up to 6 months without action from the commission, but by just notifying the appointee in the commission? Any further probationary period will require the commission's approval. So at the end of the day, it's at the discretion of the chief. And if they want something more than 6 months, I guess, or whatever number we choose, then they have to come to the commission to get approval of it.
Let's give you more management control, which I'm in favor of. Give the chiefs the call.
Yeah, I actually like that because it does something else too, which it keeps it in the bylaws and out in front of people, and if it becomes an issue, then we can address it again. It can be revisited in one of the rewrites. So I like giving the discretion, but it also keeps it in there so that we can consistently monitor it, and people can in the future as well.
Okay, Jim or Rosa?
I go along with what Jeff just said.
Okay, well then let's reflect that change, and then the chiefs have that discretion, and it's, as I think was said by both Jeff and Tom, it's in front of us that we can revisit it again if we need to.
Okay, just to clarify, so I'm removing 4.7 through 4.12, and we're just gonna have 4.13, well, it'll be renumbered. The chief may establish a probationary period up to 6 months without action from the commission, but notifying the appointee and the commission of the extension. Any further extension will require the commission's approval. I think I have to reword that a little bit.
Yeah, but I think that captures what the intent was, which would give the control, kind of right where I think we want it to be. Okay? So is that something that we should go ahead and move on to the next?
Yep, we're good to move on to the next.
Okay, and that is, I gotta get my eyes adjusted here, 5.4, and that's a complaint. I think it was the part in yellow, it's the D, or is it 5.3, thank you. So what is the norm of the other municipalities?
I don't think we have the answer to that yet.
I look around to see if I would find something regarding this, and I don't think I found anything, because the way I read it, this is basically for once the chiefs made the decision that they are suspending someone, they have to file a report with the PSC, and this is the way I read this is asking for a time frame for the chiefs to do that. How soon should they do that? We say here, it says they must immediately file a report with the commission, and we're looking for how immediate that should be.
So I think that I understand your interpretation of this and how it's written. That's the interpretation that I would come to as well. And I believe that I was the one that brought this up, and where this should come into play is not for the chief to notify the commission of a suspension. That should be done much like it is for a termination, like up in the probation section for a police officer. Just one second. So under section 3, under probation, so 3.2 says a chief may terminate a probationary status employee of his or her service at any time if the chief determines a member is unsatisfactory or undesirable for the position. This is dealing with police officers and the collective bargaining side of things. The chief shall then promptly report that decision to the commission. So I see that language being included in the statement here, 5.3. So if a chief suspends a subordinate as a penalty or corrective action, the chief must immediately notify or shall immediately notify the commission of that decision. That's what should be there, consistent with what was in 3.3. And then the time frame question is, if I am the suspended subordinate and they want to appeal the chief's decision, that's where I think the commission should put a time frame on there as a measure of guidance to the suspended employee that says within 10 business days, 15 business days, whatever time frame the commission feels is reasonable, they would need to file that appeal. Because without it, you may have, is it 90 days from now they could file that appeal? Is it 370 days?
You're not talking about the initial hearing then?
No, I'm just talking about if I'm the subordinate employee who feels that I was unfairly treated by the chief, what's the timeline that I have to file that appeal to the Police and Fire Commission?
Yeah, and I personally think that what you want is a fair amount of time, not a lot of time. In other words, I think when you said 10 to 15 days, I would kind of go with, my gut tells me, you got to make a decision in 3 weeks. And not more than that. Because, as they go further along, there's going to be other, times for appeals. There's always, specific times on appeals. And I don't know, maybe do the lawyers, does Tom or legal have a idea? Is 15 days too many? Is it the right balance? I don't know. But that's kind of what my gut tells me. I'd shoot for 10 or 15 days.
Well, I think that's one thing that I would like to bring up with this one. It says that the chief will provide that report to the commission, but I would actually like that to reflect that it's going through human resources, because human resources will then also involve our city attorney, and then it's not just the chief coming to the Police and Fire Commission, as it's sort of written here. HR is getting involved so that the appropriate legal process is also being followed. And so as far as the timeline, as far as when that appeal can happen, I would request that we get Valerie involved in that, or whoever Valerie's designee is going to be able to determine what the appropriate time frame is.
Commissioners?
So I think, like Chief Reckland said, the chief suspends one of the subordinates. The subordinate, the fact that the subordinate has been suspended is immediately sent to us, the commission. We'll know of that. The subordinate will, of course, know of that. And then we need to give the subordinate, and I think it's right to set some time, reasonable time for them to come back to the commission and say, that was wrong, I'm challenging that, and then we create some kind of dispute resolution process. I think Tom Thorson.
And you're saying that's not the initial hearing? When, after the chief comes to the PSC with a complaint, everybody has been notified.
Right.
Then we need an initial hearing. But am I hearing wrong? That's not what we're talking about.
So how a suspension would work typically is we would do some sort of investigation typically, you know, or it is possible that a suspension without pay is gonna come at the conclusion of an administrative investigation. If you're still investigating, you're gonna be on administrative leave and still being paid. So we'll go with the premise that the decision has been made by the chief to suspend for 3 days without pay. That, as Joe mentioned, is going to be done in conjunction with notification and guidance from HR, likely to also have involvement from a labor attorney because of the fact that we are in a suspension status. So what I see that is then if on, you know, July 1st, I suspend Officer A for 3 days for a violation of policy X. On July 1st, I will send notification to the Police and Fire Commission via email, likely, that says, per PFC guidelines, I am notifying the Commission of my decision to suspend Officer X for 3 days as a result of violations of policy 1, 2, 3, 4. That's it. Now, at the next commission meeting, there may be a closed session item that would go into the details of that suspension, or there may not, because if you need to put in that timeline, that would require a potential appeal of my decision. Because I wouldn't want to talk about that case in closed session or with any commissioners unless I knew an appeal was not going to be filed, because otherwise I could be potentially tainting the commissioners who are going to rule on that appeal. So what I would see then is July 1st, I've notified the commission of the suspension, which probably also would coincide with the date that employee was notified of it. The commission says, you know, for the use of this example, that an aggrieved employee or suspended employee has 10 business days to file a request with the Police and Fire Commission or an appeal to the Police and Fire Commission. That would then begin the process. There are requirements by statute, I believe, that say you have to have that hearing not less than 10 days after notification or request of hearing, and not more than 30 days. So that appeal to the PFC by the suspended employee would then kick in the hearing process. If the time frame passes and they elected not to file an appeal, it would be at that time where I would see a closed session, potentially a closed session update to the Police and Fire Commission as to what led to that suspension. That's how I would see it. I don't know if Sarah or Joe or anyone else, or if legal would see it differently, but that's how I would see it play out.
So are you recommending 10 days?
Well, I think that the commission should decide 10 or 15 days and put it in there, and then as it gets reviewed, if the legal, review or other input, whatever input the commission is accepting says 15 days or 10 days isn't enough, then we modify at that point. But I don't see any reason why the commission should not put a number in there. And I also would point out that I do think that there's not a report filed with the PFC by the chief on July 1st in the example I used, as this currently says. I think it should say they immediately notify the Police and Fire Commission, because again, a report insinuates that there's details provided, and it would be unfair to the employee and unfair to the commissioners to provide details not knowing if an appeal is going to be filed that would lead to a hearing.
I think I'm okay. I'm hearing several things. There's the rights of the accused. I'm going to use that term. The rights of the employee. What are they? Just the hearing? We have the situation where they are not going to contest the charges, so we're good. Do they express that in writing, and we have some documentation? Can they change their mind later? That's something separate that comes up. But at the same time, what are their rights in terms of the time that they have to file a complaint or to come to the PFC? So do we have the right to limit that time for them?
It's my understanding it was in the last rules and regulations. You don't happen to have the 08 version, do you? It was removed in the, actually the 08 may not have it. It was maybe in the previous version to that, and it was an oversight. So I have had the unfortunate experience to have to suspend a couple of folks in my brief tenure here. So that's one of the things that has come up is, what is the timeline? I mean, right now, you know, somebody that was suspended more than a year ago, can they file an appeal to the PFC without a time limit? And I think everybody needs closure, right? You need to know, is the employee and the employer ready to move on from this? Or is there more to it? Is there an appeal coming?
Yeah,
If the chief submits.
Go ahead, Jeff.
no, Joe, you go.
If a chief submits notice of a suspension, chances are by the time the PFC is able to meet, that suspension will already have been served. So I guess my question is, are you going to convene a meeting with this notice of suspension? And if that is the case, do you want the request for appeal to come at the time of that meeting?
I don't know the answer to that question. I do think that it makes sense to say that the employee's got a certain specified time, whether it's 10 days or 15 days, to make a decision whether or not they want to appeal the suspension. And I don't think that doesn't, change the fact that they, may make that appeal and how that happens, but they've got a limited time that they got to make that. And I think that is prudent to do.
Right.
I agree with the putting a time frame on it. I also agree with the chief's point. This should say we should be notified immediately, not a report, because I do like that. And I like that it's not getting too much information, because I think that it gives the person that was suspended the opportunity. That said, how is that person notified that they actually have the ability to a hearing and, or at least to come to the Police and Fire Commission?
So how we would do that, Jeff, is that when they received written notice, what there would be is you would have, you'd have the investigation, you'd have the predisposition meeting with the employee that would allow them the opportunity to share any relevant information that they would want me to consider before I reach my final determination. After I would have that predetermination meeting with that employee, we would then schedule a final determination meeting with the employee, and I would provide with them verbally and also in writing the determination that I'm making. In the case of a suspension, they would also have language in that written document that they have the right to appeal my decision to the Police and Fire Commission. And if with a time limit, then obviously we would include that as part of the writing or written notice that you have 10 business days to file that request.
All right, so based on that, so they are receiving notice, the notice is direct, they know what the consequences are, and they know what their actions can be. 10 days seems sufficient, in my opinion.
And the other thing you have in there, Jeff, too, is in the case of a police officer, they would have representation from their union. So they're going to have somebody who's certainly plugged into what the process would be if there's any intent on filing an appeal of the decision. And the chief, they would probably be inclined to share that within a couple of days anyway, if not right away, saying, well, we don't agree with your decision, you can expect an appeal. You may know that right away. But in those cases where you don't know it, that's why you need to put that limit on there.
And I would agree with
So I heard Jeff recommend 10 days. Everybody okay with that?
Tom, Jim Wheeler was about to say something.
Oh, I'm sorry. Go ahead, Jim.
Oh, I was just going to say I agree with the 10 days. I mean, because just looking at the process and the information that's going to be given to the officer or the party, I think that's enough time for the person to decide whether they're going to appeal or not. I don't think it should probably take any longer been 10 days.
Okay.
One clarification,
Okay.
in the case of a suspension, what's now in 5.3, that second paragraph, that's a charge under the statutes, correct? So you're filing a charge with the commission, and then the employee has the ability to appeal that charge and ask for a hearing in front of the commission. I think if it's a charge, it has to be somewhat detailed, and then the employee would be able to understand what the allegations are against them. So I don't think just straight notification, I, Chief Brecklin, have suspended this employee on this date would be sufficient. I think it might have to have more of the detail in the actual notification to the commission.
I certainly can't comment from a legal perspective on that, Tom, because I don't know the answer to that. But again, I would be really concerned if I went into much detail prior to an appeal being filed, that it would unnecessarily or unfairly taint the PFC's perception of my action, and it may not be favorable for the employee. So I still think that the appropriate way to handle that would be is the PFC is notified that that's where it's at. You obviously have the ability to either affirm or remove that decision in the event an employee appeals my decision, using me as an example. So that's when you would get, if they requested a hearing, that's when that charge, so to speak, would be heard, the facts of the investigation would be presented, and all of the other relevant information would be brought out, and so forth. So that's how I would see it play out, because adding any more information into it, other than mere notification, just really, really complicates the process. And I think the employee would have a legitimate argument to say, well, you told the commission I did this, and this, and it's violations of this, and this policy. They're already tainted.
Yeah.
Okay, can you hear me?
Go ahead, Rosa.
Okay, no. Regarding what you were asking, this came up in a training for disciplinary hearings, and it specifically says what the chief just told us, that we shouldn't even ask for the merits of the case and have any information at that moment, just a notification from the chief, just so that we're not tainted, because it could become an issue later. So the less we know at that point, the better.
That's absolutely right. I mean, the Police and Fire Commission, by statute, is supposed to be an independent appointed body. And independence means that you don't have the information in the event you need to do a hearing. Again, if there's no appeal to that decision, I do believe that there would be an opportunity via closed session to then, talk about the merits of that particular case, so that the PFC had a better understanding of how that decision was reached.
Okay, so if I heard people correctly, we want to go with the 10 days and go with, we don't need to, as Rosa and Chad just said, make sure that, it's notification that, the charges are there without going into the details, is that?
Right.
Okay. Did we take care of that section enough?
There was one other thing Rosa had brought up. So right underneath it, it says a request for a hearing before the commission should be in writing and conveyed to the president or secretary. And Rosa, you brought up the question, who requests the hearing? So we just needed to add some clarification. Is that right?
So can I think I'm on this as well here. So I think if you look at the highlights there, a time frame, well, I'll go back into that section. I do want to reiterate that immediately notify the commission is how that should be written. It would be my recommendation.
Where are you? I'm sorry.
I mean, if a chief suspends a subordinate, that paragraph, that second paragraph of 5.3, they must immediately notify the commission in writing. and then the highlighted section would go away. I also think a request for a hearing right below that is a duplicate from down below and probably just got put in there from the edit, so I think that needs to go. And then you would, so basically then say, a subordinate suspended for just cause by the chief has a right, actually, I don't even know, do you have for just cause at this point? Because that's a determination for the Police and Fire Commission to make. So, a subordinate suspended by the chief has the right to a hearing in front of the commission. A request for a hearing should be submitted by the employee or the suspended employee in writing and conveyed to the president or secretary. That should be done within 10, or needs to be done within 10 days. And then the president or secretary would inform the chief immediately that a hearing has been requested.
So one of the things that we've done over the past couple of years is based on some of the issues that presented from the general public getting in contact with our Police and Fire Commission. So locating the president or the secretary might not be something that our rank and file would be able to do. Shouldn't they be turning that into HR to be handed over to the president or secretary? I think that's the more consistent position in the city that is available Monday through Friday, typically.
Yeah, Joe, I think you're right, and you bring up a good point based upon that history last year, that should be filed with Human Resources and then forwarded to the commission president or secretary.
And I think it makes sense to have it go to HR too, because they can immediately start, because some of these you're gonna wanna get, the proper legal counsel for the city, potentially plugged in. So, sooner than later anyways. Okay.
Real quick, Tom, I'm sorry, but the sentence right above 5.4, the commission shall make a form available for filing charges, but charges need not be filed on the form. I'm not aware of a form. I don't know if we want to include this because it gives the perception that there is a form, and I don't see a need for it.
There is a form. Sarah might want to comment at least from memory, but
it's a citizen complaint form, though. It's not necessarily for employees.
Right.
Okay, that's correct.
We're explicitly talking about the suspended employee here.
Correct, yep.
Okay.
So I would recommend that sentence actually be removed.
I would strike that as well.
Remove.
Okay. Sounds good. Strike that then. I think that then takes us actually to the citizen complaint procedure. I think that's the next one that we have.
Just 5.4D, there is a highlight
Oh, yeah.
before we go down to citizen. Oh, there's a few highlights yet. This goes back to our last meeting where we talked about what if a complaint is notwithstanding, if it can get back to the chief or others to respond. So just looking at wording on this from the members.
5.4D.
Yep.
Is not standing. Yeah, it needs to be clarified more, that's for sure. I don't have a suggestion.
I think this had something to do with, after the initial hearing, we need to, the PFC has to look into the complaint and determine if they have jurisdiction regarding the complaint. And basically, if the complaint comes from a citizen outside of the chiefs, then if it's not within the PSC jurisdiction, then you're responsible to send it to whoever. I'm assuming that's what that's referring to.
Exactly.
So,
So I think that's referring to the fact that, if you don't have enough information, typically the investigation happens, independent of the police and fire commission. You're either gonna need more information or it just doesn't rise to the level of, termination or discipline. And then, as far as triage to the chief, maybe you say route it to the chief, something along the lines of getting that information back so we can handle it, based on our department rules versus that, termination.
Okay.
Say, Tom, I just asked Tom O'Day if there was any guidance in the league handbook on this topic, because it just doesn't seem to fit how that would likely play out, that an employee would file an appeal and then the police and fire commission would conduct a preliminary investigation. That just doesn't seem like it would be part of the process there.
I think this has to do with, because the PSC can get complaints from citizens. So nothing to do with an employee with an employee filing a report or the chiefs. It's from outside. So it doesn't go through you guys, doesn't go through any screenings prior to that. So that's when the PSC will do the screening and decide if there's jurisdiction, if there's basis for the complaint for us to get involved. If it doesn't, then we have the responsibility to send it through to the appropriate department or person, whoever will handle that.
So from what I'm gathering, there is a formal charge process. Someone has filed a charge against a subordinate, right? That has statutory requirements. That's this League of Municipalities handbook. And I think also you're saying if a citizen files a complaint on the website, that's not a charge. That's a complaint that's filed with the commission.
Right.
And this subsection D that we're looking at here, that's something of a citizen complaint. That is not a charge. And we, the commission, may look at that complaint and say, yes, files should be charged, or files should be charged. And then that goes to the formal process. Or we as a commission may say, we don't have authority here, this isn't for us. Send it to the chief and let the chief look at the discipline, investigate, and decide whether or not to do anything with it. Is that
That's how I see it, yes.
a good summary?
Yeah, but where do we put that?
Right. I think it's in the wrong place.
Yeah.
I agree.
Sarah, I don't know if this would be something for legal,
Yeah.
to just basically say, okay, an appeal has been filed, section 5.4 says the commission shall adopt procedures defining the details in the proceedings as follows, and then legal puts it in there, what needs to be there. And then we bring it back, obviously, to the commission for review.
Yeah, we may be able to address this in the final section as well. So we may, I don't think it's in the right spot necessarily, and we may be able to address it in the last section.
Okay.
Yep, I think that's right, Jeff. Good. That is the right spot for it, I think.
So 5.4 goes,
5.4D.
Well, let's 5.4D, but let's read the last section, you guys can do that, and then we'll determine how we want
How do we put it in there?
to, yeah.
Okay, under 5.5, I think what's in yellow is fine. We had a situation where, from the standpoint of, do we take it into open meetings or do we take it into closed session? And the reality, the proper way is that if it is, policy stuff, or it is a actual, citizen complaint, well, we take that, in open. If it is an investigation and hasn't been determined yet, well, then that's something that still potentially be closed, because we're talking about an employee. So, I don't know if that totally captures it or not. Sarah, you're familiar with that situation that we dealt with, and I think that captures that.
Yeah, and I highlighted, we added the less than 10 days. Tom O'Day, you had made that recommendation. So I just want to make sure anything highlighted in yellow is kind of what was added in the last meeting. I just want to make sure I captured all your feedback correctly. So if that looks good, I can just unhighlight it.
So I think the less than 10 days is accurate.
Okay.
I think this section 5.5, I think, is talking about the an initial hearing that triggers the statutes. And I think under the statute, that those hearings all have to be held in open session. I don't think there's any chance we can hold it in closed session if we or the employee want it.
That's correct. That's correct. Any hearing has to be open.
Say, Tom, just with that less than versus more than 10 days, I'm wondering if that shouldn't be more than 10 days where less is highlighted, because in the paragraph below it says if the filing date is within 10 days of the regular meeting, it shall not be necessary to call a special meeting. But if the filing date up above is more than 10 days prior to the next regular commission meeting, the president shall call a special meeting of the commission.
I'm only seeing that little bit as opposed to the full thing. So I trust your judgment, Chad.
So what I'm suggesting is the paragraph in 5.5 that starts the commission shall, the word less is highlighted. I believe that should be more, because if it's more than 10 days, the commission, or prior to a meeting, the commission has to call a special meeting, because you have to address the appeal within now let me think this through. Maybe I'm going to talk myself out of it.
Well, again, let's have legal make sure that we got that right. That'd be my.
But the way it's written, that section has to be more. But now I'm trying to think about, so if I file an appeal, the commission has to act in not less than 10 days, but not more than 30, right? So if the commission has to act in not less than 10 days, that means they basically have to act between day 11 or day 10 and day 30, right? So if there is a meeting scheduled prior to the 10 days, which was what Tom was suggesting, then yes, you would need to call a special meeting that puts it in between day 10 and day 30. So yeah, I have just talked myself full circle to where you were at, and I apologize.
And I think at the end of the day, there's an answer there that the attorneys can figure out for the city. But I think it is right, but yeah, let's let them figure it out. So I guess with the open and closed session issue, that sentence in the middle of this second paragraph of 5.5 that says the meeting may at the president's discretion be conducted as an open meeting session, provided that closed sessions are conducted in accordance with the statutes. I don't think that's accurate.
So let's just take that out, because if there is a hearing, the hearing is clearly open session.
They get into hearing in section 6. They talk about hearing in section 6. So that may be something else legal wants to take a look at. That whole paragraph perhaps might be a good section for legal to look at.
So I just read somewhere that if someone wants to have a hearing or something in closed session, they could request that. Yeah, they should do. I'm looking for it, I can't find it right now. Oh well.
Okay.
More review. Move on.
Citizen complaint form, Rosa.
Oh, I'm gonna pass that to Sarah.
All right, so this is directly from, we recently updated a complaint procedure form, but it looks like maybe we could look at that again. But this just documents the process for a citizen to make a complaint directly to the PFC. So we can certainly update this. I just took this straight from our website where we have the link to the form right here in the rules and regulations. I'll always have to remember to update that though, but as with any of the links. But yeah, that's the new section added.
Yeah, we looked at this already. I can't remember the date, but it was last year, obviously. And we look at Middleton and we look at Madison, their complaint form. And then I think we did some revisions and make sure that people could do it online and it was more accessible.
Exactly. It used to be a paper form that we mailed out to people, so now they have the ability to just click on it and fill it out. If they need accommodations, we of course will help them through that, and we can provide the assistance.
And we'll attach that, to the, to the rules, and of course it'll be on the city's website, so we'll be covering that base. And I think that pretty much, we go down further, I think that pretty much takes care of, we'll obviously get a new revised update, with the changes that we made today, but I think we could actually send this for, city, legal review, so that any questions that are outstanding could be addressed.
Hey, Tom.
One recommendation as it pertains to the citizen complaint 7.2.
Okay.
I'm not a big fan of putting links in policy and procedure because they change and then we don't necessarily know where all of those links are unless we have the ability to track where all of those touch points are throughout different documents. I'd rather just spell out what form needs to be filled out. It's the value of having a human resources department where they can direct the person as to where they can find that. But if we change our website, this changes, and then all of a sudden our policies and procedures through the Police and Fire Commission are affected, even though we didn't intend it to. I would just rather just name the form that needs to be used and address that outcome.
Well, it's important that citizens can find it or have access to it. That would be.
Like say, I have them, guide them through the process by contacting HR instead of putting the link there.
No problem. I can make that update.
Okay.
You could mention can be found on our website or through contact with Human Resources.
Yeah, I like that idea. And maybe you just date, I think we could date, say that this link as of, whatever, August 1st, 2020. I think it's valuable to have a link in there, even if it is, eventually it may become broken. One way or the other. Like whatever's easiest for the citizens to find it.
Okay.
Okay. With that, people okay with having this go, Sarah taking this to our legal review?
I have one more question, I guess, just about the last section, just generally. So I'm a citizen. I have a complaint. I go to the website and I find the form and I fill it out. Has that ever happened before? And so, my question, I guess, is how does the Police and Fire Commission get notified of that?
Yep, it does happen. It happened last year when we had the member contacting the PFC members when we had all the cell phones on the website. But yes, normally what would happen is someone would fill out this form, and then I would receive it, and then I would give it to the president of the PFC, and then it would go from there.
Okay.
Right.
Should we state that the HR manager will provide the complaint to the commission?
Absolutely.
Okay, well, thanks everyone. I think, we really plowed through this for quite a bit. And we're getting close to closure. The next item, it's just gonna be an informational item, but I think maybe we can even put it off to the next meeting unless somebody wants to take up training issues now. I was gonna cover, but I think let's cover it at our next meeting. If everyone's okay with that, I was going to talk about standardizing system training and, so that everybody, it was kind of like, when I joined the commission, I didn't know we had rules. And there should be some things that are systematic that every commissioner gets trained on, that everyone knows about open meeting laws, that everyone knows about, basically, public records and whatnot. So I think we can spend a little more time on that next meeting if everyone's okay with that.
Absolutely.
I am, and I agree with you. It's an important topic because I think that the reason why we're going through this process right now is because we didn't know that they existed, or many of us didn't, I should say. Yeah.
Right. Well, and a big part of it is that we have a discussion to figure out, I met with Tom O'Day about a week or 10 days ago, you know, just because I'd like to get some of this stuff systematically in place so that everybody feels pretty comfortable. And, you know, most of us start in May, and we don't get anything, you know, from the league, and that's if people go until November, or whenever they have all their training. And we really should get people at least a little more familiar sooner, so. Okay, are there any announcements? If not, I'd like to thank everyone for all your diligence in working through this. Thank everyone for, you know, really trying to come up with the best rules and regs, and, you know, again, to try to make sure we've got the best police and fire department we can based on what our jurisdiction is, so. Thanks, everyone. Any other thoughts? If not, is there a motion to adjourn?
I will motion to adjourn.
He thinks, yeah. Second?
Second.
Okay, second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Thanks, everyone. Stay safe.